Good afternoon, ladies and gentlemen. We will get started with today's webinar. Allow me to ask that all the discussants may have their videos on for us to begin the discussion this afternoon. Will be joining us later in the day. But on behalf of the council, allow me to welcome you all and allow me to welcome our discussants this afternoon to this very important discussion as we continue to look at ZIHRM Act number 3 of 2022. We did look at part 1 and part 2 in the previous webinar, and today we'll continue to look at part 3, and the focus for today's webinar will be on part 3, which focuses on matters that pertain to the registration of practitioners and members. And we will today delve into the details around part 3. Just in case you do not have an act close to you, we highly recommend that you may grab one and ensure that you're able to make your scribbles and notes as you go. This is your law, and so you are encouraged to ensure that you understand it and that you own it and that you are able to explain it back to back. And in case you have any questions, feel free to post your questions in the chat. And as the conversation, as the discussion progresses, we'll be able to pick the questions from there, and then our discussants will be able to answer the questions as we go. Before I introduce the discussants, I'll pause here and just make a quick announcement for those that attended the summit and the AGM in Livingstone. The documents were posted on the event page, and so when you go into your app, your member management app, the Glue app, you realize that you have an icon that looks like a calendar. What will happen is that you have access to all your past events, upcoming events, documents in that respect. You select documents, and then you will be able to see all the documents from the event loaded there. If you have any questions or you need any assistance, please feel free to reach out to our secretariat, and our wonderful team of staff will be happy to provide support to you. And in case you're not registered on the Glua platform as well, which is basically our member management system, it's a system that we use for managing the database for members, and it's also a system that we're using to provision all services to our members. Feel free to ensure that you have contacted the secretariat so that you could get the assistance that you need. Ladies and gentlemen, without taking much time, allow me to introduce the discussants this afternoon. We have our first discussant coming from obviously the Attorney General's office. He is a representative of the Attorney General on the ZIHRM Council, and his names are Sam Mujuda, Council Sam Mujuda. I'll allow you to just greet the members of the Institute this afternoon, Council.
Good afternoon, everybody, and it's good to be back for this webinar. Thank you. I'm looking forward to our discussion. Thank you.
Thank you so much, Council. So Council was part of the discussions from the first session. So in case you have any follow-up questions to what was discussed in the previous webinar, please feel free to be able to post your questions in the chat. Also allow me to invite or introduce next discussant who was also part of the initial webinar, and this is no other than Council Sonda Ulaya, who is Assistant Labour Commissioner at the Ministry of Labour. Council, may you greet the members of the Institute this afternoon. All right. We may be having, hi, Council Laya. Can you hear me?
Hi, sorry, it kicked me out and it was hanging, so I had to log off and join again, but I hope everyone can hear me now.
All right, we just wanted you to say hi to the members of the Institute this afternoon. We're just introducing you.
Okay, all right, thank you.
All right, thank you so much. That's Council Laya, who is joining us again on this webinar following the first session that we had. And joining the panel this afternoon, coming back from international duties, Mr. Sikatumba Owen Chilala, the CEO and Registrar of the Institute. Allow me to invite you to greet the members of the Institute this afternoon.
Thank you, CS. Greetings to you all, our dear members, and all others who are on the call this afternoon. I look forward to a great discussion this afternoon. Thank you.
All right, thank you so much. And so for those that would like to ask any questions, please, as we proceed with the discussion, I invite you to utilize the chat. Just post your questions there. And as we go, we may see if we could give one or two persons an opportunity to actually ask questions using their audio. We'll try and see how we manage time, and then we will be able to see whether or not we could make accommodation for that. Ladies and gentlemen, we will begin the discussion this afternoon with obviously focus on part 3, like has been indicated from the onset. And we are looking at provisions that relate to the registration of practitioners and the issuance of practicing certificates. And amongst very, very important themes in this part, you notice there's a usage of terminologies like member. At the same time, there's usage of terminologies like practitioner. And at some point, we want our discussants to be able to try and clarify, is there a difference between who a member is and who a practitioner is? But let's begin with the very first provision that says a person shall not be employed or practice as a practitioner unless that person is registered as a practitioner in accordance with this act. And that is according to section 11, which is the first section in part 3. The question is it illegal to practice ZIHRM in Zambia if one is not registered with the institute? And we'll ask the registrar of the institute to check that one.
Thank you so much, CS. It's a very daunting question. We will not shy away, and we will say it in very strong terms that with the coming of this law, it is very much illegal to do practice human resource in the country without being registered with the institute. So we cannot beat about the bush. Message must go. And I will implore all those that are listening in today to be good ambassadors of this message, that allow no masquerade out there to take your jobs and practice illegally. Thank you so much, moderator.
All right. Thank you so much. And maybe by contrast, the Act of 1997 left membership to the institute, at a voluntary basis. Council Laya, would you want to highlight some of the changes that may have taken place? Speaking to this shift between the 1997 Act and the 2022 Act as regards whether membership is voluntary or whether by virtue of one belonging to the practice, they must be members. And in that, would also want you to start looking at the issue of what's the difference between a member and a practitioner.
All right, thank you, CS. So this is one of the very, very fundamental shifts that has occurred with the enactment of this new law. The just repealed law was premised on a voluntary model. So the idea was, as members saw benefits, of being aligned with the institute, they would come on board and get registered. But obviously, with the evolutions in the labor market, the influx of foreign direct investment, especially from China, we saw a shift towards use of people that were not practitioners, people that were not qualified to practice HR, and then there was a high incidence of violations of labor laws at the workplace. And so our inspections often revealed the fact that many of the troubles that were occurring in the workplace were as a result of mismanagement of human resource. And we always found that it was because the person that was in charge of human resource was not conversant with HR practice or people management. And so very quickly, we discovered that the voluntary model upon which the repealed act was premised upon was not helping. And also we would get challenged by by legal practitioners who would blatantly challenge us to say, where in the law does it say that somebody who is not an HR professional cannot practice HR? And so that was one of the driving forces behind pushing for the inclusion of this prohibition. And if you look at subsection 2 of section 11, you will notice that to convey the seriousness with which we want this prohibition message to go out there, the penalty that has been placed there is quite high. So if a person who's practicing HR or an employer who has employed this person to practice HR are found to be in contravention of this law, potentially they would be liable to a fine not exceeding 500,000 penalty units. Now, a penalty unit is 13 way. So therefore you multiply 500,000 by 0.3, which is 13 way. And that's going to give you about a figure of 150,000 kwacha. So you either get fined up to that amount of money, or you can go to prison for a period not exceeding 5 years. So anything from 1 day up to 5 years is what you can get. And depending on how serious the violation is, the judge can actually give you both. You could actually get the entire fine, the maximum of it, or the maximum sentence, or anything in between. So that is the seriousness with which government attaches to this carving out of this profession and reserving it only to qualified persons. The second question relating to who a member is and who a practitioner is, in simple terms, we would say every person who has a qualification in HR and has been registered becomes a member. So at that particular point, everyone is a member. And further to that, when you now want to actually engage in the practice, you go and apply for a practicing license or a practicing certificate. as it is called in the law. And at that particular point, you become a practitioner. So therefore, all practitioners are members of the institute, but not all members of the institute are practitioners. So that is the distinction that the law has placed between members and practitioners. So as a bottom line, everybody is a member once their name appears on the register of the institute, but only those that are then as a step 2, granted a practicing license, become practitioners. Thank you, CS. I hope I have answered the question.
Thank you so much. Yes, well elaborated. Councillor Mujuda, would you like to add to that? Member and practitioner, what the difference is?
You're still muted.
Sorry for that. I was saying last time when we discussed the interpretations, and I think when we looked at the definition of what interpretation of what a member is according to the Act, I think it also tied it to the constitution of the of ZIHRM. So I think you also, I think while working out the constitution, it means that definition would have to be clarified, put in proper context by the constitution, because it does refer to that. In the previous act, it didn't do that, but this time I think it does give the constitution room to also go categorically to define the what a member will be. But also just to add on what Councillor Ulaya has added to say on the strength of on the consequences of practicing without a practicing license for a member, for a practitioner. I just want to equate to just bring a scenario that we have in the under the Law Association of Zambia. You see, there's a scenario whereby lawyers who are under the government, while you are a member of the Law Association, you may not have renewed your practice certificate. You can still appear before the courts because you are from the government. But the ZIHRM Act has not given an exception to even government employees. So everybody has to comply just like any other HR practitioner. So for me, I find it to be quite stronger than even what you would have thought from Laz. We also have a scenario whereby some people could, some time back, where somebody may not have even been admitted to ZIHRM, but because they are from the government, they could even have audience in the sub-court simply because they work for the government. But for the ZIHRM Act, it does not give any exceptions. It's a blanket requirement that anybody who try to vouch to be an HR practitioner, when they don't have a certificate, that would be illegal. I think for Laz, for lawyers, there's a slight relaxation for lawyers, and maybe that could be understood. The problem could have been that I think in the past there had fewer lawyers, so the government obviously had a challenge in maintaining having so many lawyers. That's why they were able to give this some exception for the government, but I don't see this scenario continuing for some time. Thank you.
All right, thank you so much, Council. Registrar, you may wish to probably shed some more light. We're still looking at member and practitioner, and we have right now the categories of membership, starting from affiliate all the way to honorary fellow. And some of these categories are such that they actually come with a practicing certificate. For the clarity, for our members in this discussion forum today, is everybody who is a member right now, whether affiliate, associate, full member, fellow, honorary fellow, allowed to practice HR? Are they practitioners? Are they qualified practitioners in view of the distinction that we have just discussed around who a member is and who a practitioner is?
Thank you, CS. Quite a good question there. We speak from both sides now, because as you will know, and to the comfort of members, there is this transition. And I will also proceed to answer the question that haven't been asked, just to help clarify to members, as what will happen to those that were members before this law under the old Act, number 11 of 1997. As it is now, the law has provided that those that were members then will continue under this new Act as though they were registered in this new Act. And that's the comfort for those that are holding different categories. Now, back to the question as whether they are allowed or they are practicing in all their various categories. It is yes and no. The no is just to a specific category of membership. You will know that the Act repealed provided for classes of membership itself without delegating it to the Constitution. So under there, we had a category of membership called student member. So a student member is enrolled in an institution of higher learning for human resource or related course. They are still students, yet they held membership as a student. Those were not practitioners. They could not practice. At the time they graduated, then they upgraded to affiliate. Now at affiliate, they started practicing. So from affiliate to honorary fellow, as you will know, student member, affiliate, associate, full member, fellow, then honorary fellow. All these are practiced in the old regime. In the true context of the law, however, the difference was in the practicing level. If done correctly, the envisionment of the law was that an affiliate would practice, but you know that they are just from school, they have just graduated. So the assumption is that they are just beginning their career and then they are under some supervision of some kind, entering and being oriented properly to the profession. And that's why you see that it was then given 3 years within which to upgrade to associate. So the assumption there was that if you are in a proper organization and you've practiced for 3 years, you're capable of handling other things on your own, you'd be weaned off. So to answer your question, yes, the practitioners in those given levels would not in a proper sense expect an affiliate, for instance, to practice at director level. With that background given, you are just from school, you're just joining the career or profession, so you could not practice at director level or manager level up there. But that was the practice. Thank you so much. Yes, unless there are follow-up questions.
Before I allow you to rest, sir, so at what level can we comfortably say that one is allowed to practice without having supervision? You know, without having somebody who is an HR person supervising them? Are we able to draw that guidance at this particular stage, or do we need further guidelines to be drawn before we can be able to arrive at a conclusion like that?
We are able. I'll give scenarios for clarity's sake. you will know that that provision is under the Odd Act, and the Odd Act stayed for many years. So a standard booklet was developed, which I think members, those that have followed issues of the Institute, are aware of. So that standard booklet actually highlights the levels and the competences that you must acquire to reach at a certain level. Now, I need to emphasize that what is and what ought to be may be different. With that understanding, you will see that there are people who would be affiliate there at director level, but that does not mean they had no competence. We are coming from where it was more like a social club. You will see someone practice HR, maybe in government, they have risen to director level. Then at the point they come to enroll, they would have been director already. So we had those isolated cases. But in a normal sense, starting with affiliate, an associate, and full member, we would be comfortable that someone will handle a department and run without that supervision going upwards. So that's what was pertaining on the ground. Thank you, CS.
All right. I know that we're going to be discussing issues of inspections, in subsequent webinars, and how that is going to be managed and all. But maybe very quickly, will the inspectorate pay particular attention to whether someone is an affiliate when they are put in a position of director? Or is that going to be something that will not be considered? Will the inspections only ask the question, are you a member? Like most of the adverts say, as long as you're a member of ZIHRM, you're okay to apply, regardless of what level the position is at. What is the message that our members must get from here? And what is the message that we must allow the public to be able to glean from this provision? I'll ask you to go again, Registrar, and then after that, I'll ask Council Olaya to be able to share our thoughts on this as well.
All right, thank you so much, CS. I will speak prophetically. We are aware that the law has given delegation to the Constitution to define categories of membership. Beyond that, there is a competence framework underway. So from where I'm seated here, I use the word speaking prophetically, because I may not know when the process of the Constitution is finalized, because now, yes, we are still using associate and whatever. As to whether in the definition of the Constitution, which is underway, will maintain those categories, I'm not able to answer that, because it's a process ongoing. What I'm sure is that in the Constitution and the competence framework, we will define what is needed to practice at what level. Now, that being the case, that or those documents I've mentioned then become a tool for an inspector to check. So it's not only saying, are you a member, then you are satisfied. There is a checklist. If the competence framework prescribes that for you to be at manager level, this is what you have, the inspector then will need to check whether you are compliant. Answering also the question as to the members of the public or organizations, as it were, to advertise. Following this, which we are saying, then we will follow up how also adverts are made to ensure that we are well represented. There's an example of where president sits there. You remember that recently when they advertised for a position, they specified that associate members and above. Now, this is the picture that we have. For a position that we know the job description, we will specify what person, what competences that we're looking for, which will be in tandem with the membership categories. Thank you so much. Yes.
All right. Thank you so much, Registrar. Councillor Laya, do you want to share any thoughts on that?
Yes, CS, I think Registrar has expounded on the issues quite ably. I would just want to dwell a little bit more on this issue of the transition, because I think I've seen some questions to that effect in the chat box. I think people are worried about, yes, there's this new law, there's this prohibition. How do we move forward to the new regime? And the registrar had alluded to this issue. And I would just urge the members to take time to look at the schedules to this law, especially the second schedule, which has savings and transitional provisions. And if you look at the wording of paragraph 2 in the second schedule, it uses the word a practitioner, right? It doesn't say a person, it says a practitioner, presupposing that even under the old order of things, even though it was voluntary, a person had taken the trouble to be in good books with the institution and they had registered as a member and they had registered as a practitioner. So if a person had gone through those processes, then they continue to go forward with that registration. That is the bonus they carry forward. I think the trouble, or no, it's not really trouble, the slight challenge will be with those people that had shunned registration, because now the law says you cannot practice if you are not registered. Now, the good thing is that the law is silent on what happens, but then because of this gray area, the institute, in my view, can set a time frame within which to transition everyone who wasn't registered, so that they are registered and then eventually given a practicing certificate. But you will notice also that the law in effect will not be very, very strictly applied as yet, because when you look at the provisions for obtaining of a practicing certificate, that's section 21. It says a registered practitioner, and I was thinking about this registrar. You know how when you're under pressure, you miss out certain things. I think the right word we should have used there was a member, yeah? But it says a registered practitioner, but we understand that the intention there was to refer to a member or a person who has been registered in accordance with the Constitution. So this member shall apply to the institute for a practicing certificate in the prescribed manner and form on payment of a prescribed fee. That means that the minister, on the recommendation of the institute, has got to promulgate a statutory instrument that sets out how you are going to apply to be a practitioner. And in this time frame, I think the institute can even have a general moratorium, so to say, in which people who are not registered, people who are currently practicing, can be given a time frame within which they then migrate to the new order of things. I mean, at the summit in Livingstone, I think CS had stressed the importance of the next steps, the amount of work that still remains to be done. There's a lot, and I would just urge members to be very, very involved in the consultative processes that will be undertaken in making up of these laws that will apply to the membership, to the general membership. Thank you, CS. Yes, if you are talking, your microphone is muted.
All right, thank you. I was just inviting Councillor Mujuda to speak to section 12, which speaks to application for registration as a practitioner. Obviously building on what the other discussants have said around, what can one do, right? What does the law say must be done now if one wanted to become a practitioner? What are the provisions? Over to you, Councillor.
So applying for registration as a practitioner, I think I'll go to 13. And I think last time we also discussed section 13 of what would enable somebody to be registered. Remember, that is where when we're discussing the issue of whether can a foreigner practice. So section 13 does provide that the institute shall, in considering an application, and somebody applies for, of course, in a prescribed manner. I believe that prescribed manner would have been set out by the institute, probably in the regulations. So the 13A says a registered, the institute would consider whether the person is registered in accordance with the institution. Second, whether that person possesses the requisite knowledge. You had the registrar giving an example of where you got somebody rising up to the position of director. That's when they would apply to become a registered member. But I think now here it does provide that somebody would have to be registered if they have the requisite knowledge, and somebody would have to be a resident in Zambia. So that is where the Act has come in also to ensure that we do not have a proliferation of people operating from the country, from outside the country, and claiming or operating remotely as HR practitioners. So, and then of course, somebody has to be of good standing. Good standing, maybe the Constitution again would have to describe what it means for one to be of a good standing. But it also puts some other category where the minister may come up with the other criteria, which would have to be considered when coming up with the on how somebody should be registered. So basically, that is how the process of registration would be dealt with. Thank you.
All right, thank you so much. Registrar, what is the prescribed form through which these applications must be received at the moment?
Thank you so much. As rightly observed, that there is also a bit or more work to be done. You will know that we will prescribe forms. Currently, we're using both the electronic and the physical forms that detail what is required. But as we have said over and over, is to emphasize that all those will be reviewed and redescribed to suit what is pertaining on the ground now. Thank you, CS.
And maybe if I could just come in, CS, just one observation.
Sure.
Another observation that I've discovered is that one thing that the Act does put is that it puts some of the conditions that it places, like on disqualification for somebody to become a member. When you look at the qualification for somebody to stand for council, the Act has also put the same limitation, the same conditions for somebody to be able to stand as a member of council. You will find that those are the similar qualifications for somebody to become a member. So if one, from what I find is that if one is able to qualify to become to be a member, obviously it would be quite easier for somebody to also be able to stand for council. So it does put a process of disqualification for somebody. For instance, if somebody is convicted and discharged bankrupt, you will find that these are the same qualifications that also extended for if somebody wants to stand as a member of council. I thought I just mentioned that.
All right, thank you so much. Let's maybe, I know we've in a way touched, I think section 15 coming down with the disqualification from registration just being discussed now. Issues around certificate of registration as a practitioner, maybe a quick commentary here. It says in a prescribed form, and we've seen, discussions. Certain times members have asked why don't we issue electronic certificates? Why don't we issue certificates in whatever manner that different practitioners would want? When the law says in a prescribed form, what does that mean exactly? Is there a room in the current dispensation of law for the institute to get creative with how this certificate is going to be issued? Or is it something that the institute cannot maneuver? There is a defined way, and that's the only way that these certificates must be issued. Councillor Ulaya, would you want to share your thoughts on that?
So there isn't any magic with the words prescribed manner, prescribed form. It's just trying to help with issues of authenticity. Yeah. What is this form that the institute is going to adopt? Is it going to have a coat of arms? Is it going to have a bird? Is it going to have an apple? What are you going to put there so that when somebody sees it immediately on the face of it, people will be able to recognize, oh, this is a form from ZIHRM. Now, as to whether you will insist on this form to be physically lodged is up to you. This is why now, after you have come up with the form itself, what will be there? Will you require details such as your name, your age, who you were last married to, all of those details? That is what you will set out in the form. And that form will have to be lodged in a prescribed manner. Should you come, let me be silly. You know how when we go to Chilanga Mulilo, if you are Bemba, they'll put things on their heads and then we'll go backwards. That is the manner in which you take things. You don't go forward, you go backwards. So in this particular way, the regulations can say, as you are bringing this form, you put it on your head and come backwards and then lodge it. Okay, that was just for emphasis so that people don't forget. So the prescribed manner is where now you can include all of those innovations. Are you able to do an electronic submission? Is it 3 copies? You go to town, all right? If you insist on a physical copy that is dropped off at the secretariat, that's all up to you. So it is possible. The law has not limited the way in which you will do this. That is why it has left it to regulations. And obviously, that regulations are the culmination of a process of discussions. Yeah, so the prescribed manner is something that will be agreed upon as the most, the most efficient way. And it can include innovative ways in which this application form will be lodged into the institute. And there's also the issue of a fee. It also will be prescribed, meaning that it will not be issued or promulgated by the minister without consultation with the council. So the council is going to advise what this optimal fee will be for lodging of these forms for registration and for practicing certificates. Thank you.
All right, thank you so much. Section 17 talks about a practitioner registered under this act notifying registrar of any changes in the particulars relating to registration within 7 days of that change. Registrar, what modalities are in place to ensure that these notices get to you within 7 days? And what does this mean? What particulars are we looking at here? Could a change in employer be one of the particulars, for example? Just for the purposes of enlightening members of this discussion this afternoon, could you please share your understanding of Section 17?
Thank you so much. Yes. What changes we're looking for? Again, we will reemphasize the point that we will define further. Of course, maybe for our, on a lighter moment, for our sisters, they may change names. But names look very permanent, and NRCs permanent, and all those things. But the employer, the region, as you will see that at times when there are requests that come to deal with certain matters, they would want the region of a person, the sector. I'll give an example of what is going on now with the Civil Service Commission. They are establishing the human resource committees across the country. It is expected that to be cost effective, for instance, if we are establishing a committee in Kaoma, we pick practitioners that are around there so that the efficiency matters, they are within reach. So that is one of the example we can give. If you are then changing or moving geographically, it is expected that you notify us so that we know what to do. And we answer the question as to whether we'll be able to maintain you on a committee in Kaoma while you are in Lusaka, for instance, or you have gone to Kasama, for instance. So those are some of the things. The other part of the question is on the modalities. We will sing our song on Glue Up. We know that this physical paper at times may delay. Imagine you are posting your form for change of location through the post office. It may take maybe 2 weeks to reach us from Kaoma to here. So what we have put in place is that this membership, the Glue Up, it will be able at the click of the button to help you reach us so that we see those changes. So thank you so much, CS.
All right, thank you so much. Suspension and cancellation of registration. That's under Section 18. Councillor Mujuda, I'd like you to speak to that. And then obviously there's the aspects of re-registration that come under Section 19. Probably you could speak to that. I know Councillor Lai already touched issues around practicing certificates on Section 21 and Section 20. But I would want to follow up with a question there. So probably we'll stand by for a follow-up question for Councillor Lai just after Councillor Mujuda looks at Section 18 and 19.
Okay, so Section 18, I find it quite interesting. It gives 4 scenarios under which somebody's registration can be suspended. The first one is it involves where the institute discovers that somebody obtained the registration through fraud or misrepresentation. Then the next one will be, the second one is where the professional conduct committee, is it the disciplinary committee, have found that this person has misconducted themselves, they've acted unprofessionally. Then the third one is where somebody has been convicted. Then the fourth one is where the circumstances that the current circumstances of a person have changed. For instance, if somebody was a resident in Zambia and he ceases to become a resident in Zambia and maybe goes to China, while in Zambia they were a registered practitioner, but then they go to China. So the circumstances of somebody being a resident changes, they change. So those could lead to suspension. But then the other thing that I find interesting about Section 18 is that the different circumstances involved, they also call for a different form of appeal process that is involved. And I know the appeals we're supposed to deal with them when we're dealing with the general provisions, but I'll just touch briefly on them. For instance, what the law provides now is that if somebody is going to be where somebody has their certificates suspended for an offense under A, the process is that that person would have to appeal to the minister. Then if that person is not happy, then that person would have to appeal to the High Court. That is for a suspension which takes place under A. Then where it happens through B, it could be that somebody, first of all, could there would have two scenarios. If maybe the suspension is when it's through the PPC, Professional Conduct, or PCC, Professional Conduct Committee, then somebody would have to appeal to the disciplinary committee. Then from the disciplinary committee, now you don't go to the minister, but you go to the High Court. Similarly, if it's the DC which finds somebody which the certificate is suspended through the DC, it means that from the DC, somebody will not go to the minister, but they would appeal direct to the High Court. Then, of course, we know where somebody's practice certificate is suspended through conviction. Until that conviction is cleared, that suspension stays. And I think for D also, until those circumstances which could have led maybe for somebody's registration not to be valid, if they come into the jurisdiction, they become resident, then they would, I believe that their registration would stand. Thank you.
All right. On, the suspension of one's, rights to practice based on, I think Section 18, subsection 2C, the one that speaks to a practitioner being convicted of an offense under this act or any other written law and sentenced to imprisonment for a term exceeding 6 months without the option of a fine. What could we be looking at here that could probably, qualify for 6 months under other written laws? Could traffic-related issues, for example, be covered here? Not so, or so? What other things could we be looking at? I'm sure there could be anxiety around what qualifies under this. Councillor Olaya, would you want to delve deeper into that?
Yes, and that is the basic reason why statutes will have a provision like this, because they understand that there are certain things, you know, that certain situations that we might find ourselves in, over speeding, all right? For instance, I drive very fast, and the only reason I get away with it is that I have a GRZ number plate. I take advantage of it sometimes. But yeah, you know, most of us will, you know, sometimes go over a speed limit by 5 kilometers because you were thinking about something else, you know, you're truly not concentrating and you didn't mean to infringe the law, but we find ourselves infringing. And sometimes, you know, you might go out to some place, you know, and you get into a brawl, you know, with somebody, you fight, and yeah, you are taken to the police for a common assault. So those are just in criminal law what are called misdemeanors. So when you look at the way our penal code is structured, offenses are classified either as a misdemeanor or as a felony. Now, a felony are those offenses that society or parliament has ascribed some seriousness to, and that mark has been put at the 6 months mark. So if you have a conviction that is 6 months or above, then yeah, this law is saying, okay, pay attention, you know, then this person really should not even be considered for some of these privileges or rights that are being accorded. So it's a policy issue, really, and it is one that is more regulated under the realm of criminal law. Thank you.
All right, and I think Section 19 tries to address what happens when, you know, one wants re-registration. Maybe you could quickly speak to that, Councillor.
All right, for re-registration, I think that Councillor Mujuda had given a very excellent example. He given an example of say since 18(1)(d), where it says circumstances have arisen which disqualify you. So imagine a person who was resident in Zambia, a non-Zambian resident in Zambia, they register to, you know, as a member and subsequently as a practitioner. And for some reason, maybe they are deported, okay? So they leave Zambia. That very fact disqualifies them from being registered as a member, and by necessary implication, if you see section 24, subsection 4, where it says that when the certificate of registration is cancelled, all right, immediately your practicing certificate also becomes void, it falls away. So imagine this person has been deported because of whatever reason. It might be political, you know, maybe the person appeals and then it is found, okay, really, this person was fairly treated. The evidence did not even support maybe government taking that particular decision. And after being deported, they come back into Zambia. So they come back and they are not a member, they don't have a practicing certificate. In that scenario, then they can use section 19 to apply for re-registration. So that is latching on to the example that was given by Councillor Mujuda. That is how I can explain one of the possible circumstances under which section 19 would be invoked. Thank you. Okay. And maybe also just to take advantage of being on the floor, I wanted to also weigh in on what Registrar had said on section 17 as to the changes that you need to notify. I wanted to stress the fact that normally what the law is looking for there are material changes, those changes that might impact your registration, changes that might impact your rights or obligations under the law. So for instance, if initially you had registered as a student, yeah, and you have since graduated, you don't want to still be at student level because it's going to impact what sort of level of jobs you're going to go into. So you have 7 days within which to notify the registrar. So whether you're going to do it electronically or you're going to do it by post, when the registrar mentioned the issue of the post office, yeah, postal things take, we call it the snail mail in law. So there are other rules that courts, you know, or jurisprudence has developed to help with situations like this. So then we'll look at when do we start to count the 7 days? We'll look at when it is that you went and you posted that letter. So if the scenarios happen today, I have graduated today, and within these 7 days, I go to the post office and post, then I have met the requirement of notifying you within the 7 days. That's an entire realm. But I just wanted to stress the issue that the changes that the law is looking for are those material changes that might help the institute make a determination about the status of your registration. Thank you.
All right. Around practicing certificates, you notice that membership is being deemed to be almost in perpetuity. Like you're almost a member in perpetuity, but then there's a requirement for there to be renewal of a practicing certificate. Maybe we could just speak to that as well. Very quickly, Councillor Ulaya, that was a follow-up question I wanted to ask on being a member and having a practicing certificate.
Okay, so membership, for so long as you remain in good and regular standing, should be something that you have until death do us part. Yeah, and so it would be because the circumstances for registration to be a member are those that you would already have met. It wouldn't make sense. It would be a bit impractical. It would be onerous to expect people to submit the same information that will not change. So what the law then does is that once you have this registration, it sticks with you until you die or until it is revoked, you know, through a suspension or some cancellation. So therefore, when you are a member, the law does not give you then the right to immediately begin to practice, because that is you going over the first hurdle. When you have passed that first hurdle, what you then need to fulfill is the requirements to practice, all right, which are then prescribed under Section 21. So apart from, and also the manner of applying for this practicing certificate will be in a prescribed manner and in a form, and there will be payment of a fee that will be determined through an SI. Now, the section itself says the minister will issue an SI, all right? That will provide for the terms and conditions for issuing this particular practicing certificate and the types of CPD training and other information that will be required for the issuance of the certificate, and any other matters as will be advised by the institute. So once you get this practicing certificate, then you can lawfully engage in the practice of HR. Now, the law has left it open. Now, this practicing certificate is different from the certificate of registration. So Certificate of registration as member is in perpetuity, all right, if you are in good and regular standing. The practicing certificate, the institute will determine whether you are renewing it yearly or every quarter, which is obviously not advisable, but this one will have a specific duration, meaning that you can be a member and a practitioner this year. But if you don't renew your practicing certificate for the following year, you remain a member, but you then cannot legally practice. And if you attempt to do that, Section 20 says you would be committing an offense. So both you and your employer also will be treated exactly like a person who isn't even registered. You will be subject to a fine of not exceeding 500,000 penalty units, or imprisonment for a term not exceeding 5 years, or to both. So it's a very, very serious matter. This law is not playing around. It wants to sort out the mess in this sector. And so we also need to, and I think that's the key message that members should take away from today, that you have to know the duration of your practicing certificate. Make sure that you are in good and regular standing. Make sure that when there's cause for renewals of practicing certificates, you are doing them in time, because you can't practice for 2 days, without the practicing certificate, in the hope that on the third day you will go and have it renewed. It's an offense to practice even for 1 hour without a valid practicing certificate. Thank you.
All right. In case somebody doesn't want to practice in that year, what does the Act provide? And maybe you could also just, I'm interested to get some commentary around Section 21, subsection 3, and the provision of, issues around the type of continuous professional development and training and any other information required for the issuance of practicing certificate. Does this stretch to renewal as well, or is it just to the initial issuance? Would the institute be expected to indicate that if, for example, your practicing certificate must be renewed, you must have been able to demonstrate that in the previous year you remained current with this or that and stuff like that, in that respect? Maybe we could get Mr. Chilala to comment on that very quickly. Councillor Judah, you could maybe share your thoughts as well, and if Councillor Olaya would have anything itching, she could also come through.
Thank you so much. Yes. Let me start with the issue of the period that you are not practicing. The law has given that leeway to, and I think the understanding here is we may have people who have pursued different careers or trainings. So at some particular point, they may be using, let me give an example. I may be an HR practitioner, I'm a legal person, and then maybe in this phase, I'm more inclined to the legal issues than the HR. I may apply or indicate to the institute that in this period, I will not be practicing human resource. That then does not mean I'm no longer a member. As we've heard and read, I'm a member in perpetuity unless those other issues are kicking. Maybe I'm found guilty under this act or another law. So in that period, the institute will hold my membership until a time I want to reignite it. And we are assuming we are understanding the two on membership and practicing. It simply means I'm not practicing that period, but that does not preclude me from being a member. I'm a member, but I'm not practicing that period. And therefore, the institute will deem me as such for that period of time until I reignite or indicate to the institute that I want to get back to my practice in this line. Let me address the issue of CPD, continuous professional development. We must say there are two things here. The entry issues in what the legal side call bar exams are a different thing that is at entry. If the institute wants to go that route where you have done your training in human resource and at the entry point, you are subjected to an exam, that's a different thing. If that happens, it's in the hands of the institute. CPD, as the name suggests, is continuous in nature. This is with understanding that even if you did your master's in human resource 2019, 2002, knowledge keeps changing. I would at this moment give example of the laws. If you did your Master of Human Resource in 2018, by 2019, we have the Employment Code Act. A lot has changed. You cannot say, I already learned and I'll stick with my knowledge, which dealt with CAP 268. You'll be lost and misdirect the company. So we need to continuously upgrade our skills and knowledge. That's where it comes from. Now, this coming of CPD has implication on practitioners. The institute, for instance, like any other institutions, may want to attach CPD points for your renewal or for your movement from class member A to B. That's within the institute, provided it is prescribed. So going that route, then it will mean annually maybe you'll be expected to attract, let's say for argument's sake, 30 CPD points. Then the institute in these prescription documents will go further to say which event attracts how many points. Let's say for argument's sake, you have the annual regional summit, you have the convention. If these are put at 10 CPD points, then you have workshops which will apply. Then your attendance to this will accrue you some points, and then it will be done that way. Thank you so much, yes.
All right, thank you. Councillor Mjuda, would you want to add anything to that?
I think the registrar has ably handled that part, but I thought maybe we could also just talk about the issue of suspension and cancellation of a practicing certificate. And I think obviously, and the gravity involved. I think as you see what section 28 does provide over that one, where it involves where there is a cancellation of the practicing certificate, the practitioner is actually expected to surrender the document. So you look at the gravity of the situation, and I would like to liken that one to a scenario under the legal profession, whereby when your practice certificate is suspended and another scenario where you are struck off the roll. Obviously, when you are struck off the roll, that's the end. Maybe God's case. But then for the other one, when you are suspended, it may be a temporal setback. So that's how I look at that. And in terms of, I think it speaks to the gravity of the offenses that one faces. Thank you.
You bring a very good dimension, Council Mujuda, around suspension and cancellation. Maybe we could just delve a little bit more into that. What does suspension mean, and what does cancellation mean? What would be the difference, and in terms of implication, and also probably in terms of circumstances that would cause either suspension or cancellation? Council Mjuda, you could take that, or Council Lai, if you're itching to take that one.
Maybe Council Lai can take that one.
All right. So suspension or cancellation, what do we see as circumstances that would lead to that? And by implication, what's the difference between a practicing certificate being cancelled and the practicing certificate being suspended?
So what I would say is that a suspension of a practicing license is bad. Yeah. Cancellation is very, very bad. So both are not good. So we are not looking for a situation where our practitioners will be found in this realm. So suspension, if you look at the acts, can arise from different angles. It can be as a result of a disciplinary issue that is before the PCC, or that is before the disciplinary committee. So sometimes the suspension is a sanction, yeah? After you've gone through a disciplinary issue, they found you guilty, they can suspend you for a period of time just to punish you and to send a message that, we are very serious about maintaining the ethical standing, okay, and the integrity of the profession. There can be a suspension that is given during investigations, yeah? So we don't want you anywhere working and, creating an image that the institute is tolerating some kind of behavior, because the institute on its own accord can initiate disciplinary action, and then they can invoke those provisions. Now, when it comes to cancellation of the certificate, it means that you have been guilty of gross misconduct, and so you are not found worthy to practice. And that's at the tail end. That is what Council Mujuda spoke about in likening it to you being struck off the roll. Now, if it's cancellation of the certificate of registration, that one, even though you have been practicing and say you have not misconducted yourself, yeah, you have not been taken before a disciplinary committee, so your practicing certificate has been, is in order. But then some circumstances have arisen that reveal that you forged some documents, there was fraud, there was concealing of some material facts, and the institute decides to cancel your certificate of registration. Even though you have been a good practitioner, all right? The very fact that your certificate of registration gets canceled, the law says automatically your practicing certificate also should be canceled. It is void. So those are the sentiments I can give around the two issues. None of them is a good thing. Suspension, to give a bit of, a bit of comfort for those that might find themselves in this scenario, is that it's not the end. But then if you don't reform, that might be a sure path, downward path towards your end. So try and stick clear, stick out, stay away from any scenarios that would cause a suspension and a cancellation of your certificates. Thank you.
All right, thank you so much. Before we go to look at issues pertaining to the registration of firms and issues around registers and the like, I just want us to attend to some questions that have been posed. The first one says, we have a case of unregistered persons who have been appointed to act as manager HR at my institution. I advise in line with the new law, but all in vain. How can I formally report this? And I've engaged officials from the Secretariat, but there is no guidance so far. Please guide. Registrar, would you want to take this question?
Thank you so much, CS. There are diverse ways to report that. Officially, in full view for those that are courageous, say this is wrong and I come for this. We also accept those that in the spirit of whistleblower to just alert us. In that way, we can do an inspection and discover on our own. So the Secretariat is open. In all other forms, whether you walk in person to come and address us, via phone, the official lines we have, via email, or handwritten letter, all those forms that we can receive those. And we will, depending on the circumstance, approach the matter. If you don't want, because we at times, at all times, I should say, are mindful of relationships. Others may know that I report into this. If they know that it's me who reported, it will be sour for me. All those are acceptable. We will then approach it differently ourselves, provided we know where it is happening. So what is important for members there, and these that are listening in, to tell others that do reach out and to the Institute. We will attend to all those in whatever form they come, provided we know where it is happening. Thank you so much.
If someone wanted to blow the whistle, how do they do it? Where do they write? Who do they call? Are there numbers? Is there an email address? Should they come to your office? What should they do? What have we put in place?
Thank you so much. I was trying to censor my words, but I should say that close members of the Institute now, because you will know that they would have interacted with the Institute a long time. They know that our headed papers, our correspondence, always they have our email address, the main one. They have the direct line, all those. But to answer this question directly, because we considering the public out there who may not even be our members, walk into our office is allowed. Those that may know the email address, as I said, you can write to us. Those that may know the number, they can reach unto us. I'm using it, walk into the Institute, because professionally, all correspondence must be referred to the registrar, but we are not restricted like that. As a public, you may not know that. Just reach unto us. All we're interested in is to know, to get the information of where that thing is happening. In case there are those that want to take note right now, these basics, others can get to us behind the scenes, but the line that we have, those that are taking note now, I can call it right now. 0955 404075. By email, we are at info. Now the info is without R. That's info.ZIHRM at ZIHRM.org.zm. They will reach us in those contacts and in many other forms. Kindly reach us. Thank you so much.
Right. Thank you so much, Registrar. We proceed. The other question was, what measures are being put in place to ensure employees adhere to the Act? Would there be inspectors doing spot checks? Kingfree, the answer is yes. We ask you to attend the next webinar where we're going to be discussing the inspectorate, because we'll look very closely around issues pertaining to the inspectorate in that particular discussion. What is the deadline for organizations to have their HR people registered and obtain practicing licenses? What's the deadline? I think we've tried to address this question, but I can still allow that the discussants quickly probably just address it for the purposes of clarity in case somebody missed what was indicated initially. Is there a deadline? Council Laya, you discussed this. Would you just want to repeat what you said?
Okay, so it depends on what your status of registration was before, in which case the law has handled it already and deemed those people to still be registered under the new law. But for those that were not registered, I think that is where they would depend on any dispensation that would be given by the institute. And also that dispensation should align with whatever time frame will be anticipated in the promulgation of this SI that will give the form and the manner and the fee for registering as a member and as a practitioner. So I think that's when the institute firms up exactly what should go into those SIs, then members should just look out and see what sort of timeframes would be advised to the members. Yeah, that's all I can say for now.
Right, Registrar, would you want to add to that?
Thank you. I think it's well articulated. Thank you, sis.
All right. Thank you so much. Next question is, I am an associate member. Does that mean I'm a practitioner, or there is need for a separate registration? I think this was adequately dealt with. We did speak to the fact that certain categories of membership attract practicing certificates, some don't. And so would basically dwell on that, and that based on what level you basically, practicing HR in terms of your organizational hierarchy, could be manager or director, it would be not appropriate for you to be an affiliate member, for example, and then you're a director or a manager. So I'll just gloss over that with the responses that were given earlier. Does one's qualification determine the type of registration, category of registration they get, e.g. affiliate, associate, member, etc.? Does anyone with social science qualify? Is there a list of academic fields other than human resource management that qualify one to register as a member? Registrar, please, may you give some guidance on these issues.
All right, thank you so much. Yes, they are related fields, but as we say, we are yet to define and redefine more in the competence framework. As it stands, the related fields away from HR were public administration, business administration, industrial psychology. Those were closed and defined in the standard booklets. If you had eyes on it, it would speak to those. Those that have done law, they were yes, but there is a precondition. Certain fields, the starting point is that when you approach the institute, they will check through, if it's not HR proper, they will check through your transcripts to see which components are related to people management in your course. Emanating from that, they would prescribe that you undergo within the institute a short course to bring you up to speed on certain issues that they may deem missing from your training, so that you are able to handle those matters. So that's how it's been approached, that they are more redefinitions that are going to happen in the very near future. So look out unto those that are coming. Thank you, CS.
All right, thank you. Councillor Mujud, I'd like you to check the next one. What is the value of membership when you are outside the country? For example, I was outside the country from 2006 to end 2016. I guess somebody is asking, should a member who intends to go live out of the country for some time still, maintain either membership or, practicing license with the institute?
Again, that person, it will depend again on the question. Does that person want to go and practice where they are? And obviously, if you are going to go to a jurisdiction, for instance, Kenya, they might require that you have specific. You would have to go through the process again of registration there. So while you were in Zambia, you are a practitioner. You may I find it to be quite valuable that one still maintains their certificate as a good standing member of the institute. I think in terms of updates, I think they'll be able to benefit from different kind of updates and information. Thank you.
All right, thank you so much. All right.
Yes, just to add on.
Yes.
I think as earlier dealt with in terms of section 25, I think we did address this issue, but now that it has come back, we just need to reemphasize the going out or the remaining within and not practicing for a specified period can be treated together. So if you look up section 25, you will discover that if you want to travel out for other things, and you can approach the institute and say, look, I won't be in the jurisdiction where I'll be practicing this. Your name is maintained in what the law has said, non-practicing category, and held for that period so specified. So when you get back, you indicate to the institute that I'm back, I want to be activated for practice. So it is in that spirit that your name is maintained as a member for that period until you return back. Thank you so much.
All right, thank you, Registrar. The next two questions, we'll read them together. And basically, they speak to issues of whether, a non-practitioner can issue a contract, or whether a foreigner can issue an employment contract. So in this case, the question says, in a case where a director is a foreigner or Zambian that is not a member of the institute, can they still issue employee contracts or sign off on employee contracts? I guess it's not just employee contracts, but on any other employment related documents, all right? It could be appointment letters, it could be other documents. And the other question that's very alike to this one says, since the requirement is that a practitioner should be a Zambian or living in Zambia, is it true that practitioners should be the ones to issue or approve contracts and not company directors? So I think there's a specific and direct question that speaks to what constitutes the practice of HR. Does issuing a contract constitute practice of HR? And issuing conditions of service, does that constitute practice of HR? Can somebody who is not a practitioner take contracts for attestation to the Ministry of Labor, for example? Or can they participate in what has been considered as HR? Councillor Lai, would you want to take your first sweep at that one?
Yes, CS, I wouldn't want to reduce the practice of HR to that very, very elementary level. And I think it is that understanding of HR that has cost the profession a lot of development over the years. And obviously you can see that because these people have been issuing out these contracts, you can go online. There are a lot of standard contracts out there. Anybody can download it and give it to somebody else who reads it and they are okay. And it's a contract. Now, that is why this particular law has been very, very deliberate in giving a precise definition of what we are thinking of when we say HR management. It's a holistic view of the practice of people management. So if somebody takes a small component, if the process has been done, you have developed the policies and your director signs. Signing off on a contract of employment is not practice of HR, because you'll understand that in an organization, there's hierarchy. There are responsibilities, there are levels at which people can do certain things and others which others can't. And so in the order of things, you'll understand that the director or, maybe a senior manager at a certain, in a certain unit might be the one who has this delegated authority on behalf of the company or an entity to enter into this employer-employee relationship. So to that extent then, signing off on a contract of employment is not a practice of HR. Yeah, so that needs to be understood. And that is why we need to be very clear that HR is this very critical interface between operations, between meeting of strategy and getting the right people to execute this strategy or to, be in charge of the operations of an entity. So if the HR director then wants to be the one in charge of the development, of conditions of service, the implementation of the conditions of service, then they are getting into the realm of the practice of HR. They can, as on the business side of things, input in this discussion. Yeah, because conditions of service are a cost to the company, so you cannot divorce them from it. But in as much as they will input, if they allow the practitioner then to go and refine, input all of their training into these conditions of service, and then take them to the appropriate authorities for signing, then there isn't a problem. But the key thing to note is we need to, all of us, read that definition of HR that is given in section 3 And the moment that you see at your workplace, and it's very easy to tell when somebody is infringing in your space. You will not need to come to the Ministry of Labor or to the Institute to say, can you actually explain to me what this definition is? If you're an HR practitioner, somebody is stepping into your realm. So the first point of call is to look at that definition of human resource management that has been supplied in the Act. So on the face of it, my initial reaction would be signing off on an employment contract is not practice of HR. Thank you.
Okay. Registrar, would you want to add there? I think the response from Council is mere signing off of a contract is not practice of HR, but the active development of a contract of employment, for example, conditions of employment is very much HR. I think have I paraphrased that correctly, Council? All right, great. Registrar, would you want to add to that?
Thank you so much, CS. I think well put. The practice of human resource is in charge of that whole process. That does not mean they are the only players. That wouldn't be correct to say. Let me start by the process of developing conditions of service. You are in charge, you are guiding because you know what the law says, you know what the environment is in Zambia and all that. But that does not mean you will just sit as HR in your department and develop for everyone. No, there's input for others. At that input level does not mean they have practiced your HR then. No. We need input. And as far as it should be, HR must encourage this engagement with line managers, with superiors, with employees here, and everyone on board. That's the proper management of people so that you have a holistic understanding of matters. And to answer the specific one on the signing, once you know that the due process has been followed, your documents have been approved, for instance, by labor, they are good in your eyes, you've done your HR. The signing is not necessarily an issue because the documents that is being signed is correct in your eyes. It is correctly put, let's say, someone who will be signing on the contract for your director, HR, maybe the CEO up there, who is not HR. Does that make it wrong for them to sign? They are the employing authority. You would have done your due process and then they will sign. It's still fine. Thank you so much.
All right. Is there any leeway that a practitioner has under the law? Let's say they actually made a draft of the contract that is properly couched, or conditions of service are properly couched, but because they're not the final executor, the executor decides, I'm going to change something, and it's actually inconsistent with what is provided for in the law. What would be the obligations of a practitioner in that instance? I don't know whether my question is clear.
It is clear. I think I have understood and I've understood it. And this is where part of the intention of this law is to allow practitioners space to be ethical, space to be professional, without the fear of reprisals, without fear of certain consequences that people have been subjected to. So the essence is to allow practitioners to be able, in a very professional manner, to indicate, for instance, that this particular provision is against the labor law. This particular provision is against public policy. This particular provision is going to, there are certain things that are not really they are neither against public policy nor against the law. They seem okay for all intents and purposes, but as an HR practitioner who is in that local environment, you will understand this is going to demotivate staff. And we are trying to increase productivity, all right? So you taking away this benefit, or you doing this, or you increasing working hours by 1 extra hour, okay, within what the law allows, okay, is going to cause workers to be more tired. By that time, maybe there will be a lot of mistakes, you know, they will become prone to occupational accidents. You know, you can guide on a realm of issues. And if you are not, if that guidance is not followed, for me, that is where, and you are castigated for it or harassed for it. In those specific circumstances, this is where I would like to see the Institute standing up for practitioners using their powers under Section 4, where they're supposed to advance, you know, the human resource management profession and to promote its interest. Where somebody, a practitioner, can run to the Institute to report this particular issue. And if we can have a situation where, you know how employers and employees will run to the Ministry of Labor, I am hoping that the Institute can create a mechanism where in those instances, not really a grievance to say, but in those instances where the HR practitioner is failing to convince or get some traction, they can get the Institute to come in an advisory position so that the Institute can bring to bear its HR views on the matter, and therefore help the HR practitioner in the work. Because also they must, if the person is fired and the person wants to employ somebody else, the Institute has got to be able to write something and make it very difficult for employers to just hire and fire HR practitioners because they don't want to hear. So I think those are in my head, me running ahead of myself to try and see and fix certain things that haven't arisen. But essentially, what this law is trying to do is, in my view, create a space within which a practitioner can freely offer their legal advice, because they know if they did something and somebody goes to complain and the Institute comes to look and say, hey, man, you were here, look, this is serious incompetence, this is serious neglect of your duty, you might get your license suspended for something like that, and you lose your income. So, sorry, there was an incoming call. So in my view, I think that it creates a space, a safe space, hopefully, for practitioners to be able to give their candid opinions to their superiors, to say, no, we can't do this. It's against the law. It's against public policy. It's against all the rules we have learned about people management. Thank you.
All right, thank you so much. I see we still have a few questions here, which we'll take. We've taken note of them, but I would just like us to, I think, address the final provision that we need to look at under section, under part 3, and this speaks to the regulation of firms. HR firms, and obviously briefly we could talk about registers as well, but with key focus around the regulation of HR firms. Now, obviously, this is a new provision in the sense that this was not provided for under the 1997 Act. But there is a specific definition of what constitutes HR firms, and it refers to what Section 29 provides. What does this provision change? What exactly was, the intention for this provision, and what are the key things that must be noted here in terms of, what the implications on, consultancy organizations that may have been registered under, PACRA as consultancy organizations providing HRR related, services, because PACRA has those categories of, registration where you actually select, what you affiliating to, or even with, organizations that may have registered with the Ministry of Labor as, employers or labor brokers, or things are related in that particular respect. Quick reactions, lady and gentlemen. I'm not sure who would like to go first.
I could go first.
Okay.
So the inclusion of firms was to ensure that we do not leave any loopholes. Obviously, in the foregoing provisions, we have seen provisions in the law that are regulating human beings, in a typical workplace scenario. Now, what about those ones that are employers themselves? They are offering consulting services either as a company or as a business name, all right? Or as a partnership for that matter. And you'll understand then that depending on the type of registration that you have, it has different legal implications. For instance, if you have registered a firm as a company, there's a separation in legal personality. So what this particular provision is requiring is that as a person, you need registration. But if it's a company, it's also going to be, it also will be required to register. The same with a business name. Now, it is possible, that people can go around some of these things. If there's requirement for you to practice HR as a person, you can go and register, but then you can get into, a partnership with somebody who's not a practitioner. And then it is possible that then all of these other non-practitioners will be using your one certificate to do a host of other things. Now, what this particular provision is intending is that, well, I don't know what the particular terms and conditions will be, because subsection 3 says the minister will issue an SI in consultation with the institute, all right, on the terms and conditions for the issuance of a certificate of registration of a human resource firm. So if you want to go the route that LAS takes, a practitioner cannot be in partnership with a non-practitioner, for instance. And I foresee that condition being one of the key conditions that the institute would place. Or if you haven't thought about it, I would highly recommend that you do it, because then what would be the essence of regulating human beings, and then they go around the law by creating separate legal entities that can achieve what we are trying to run away from, and that is non-practitioners being able to practice HR. So the conditions are yet to come. We will see them because they're coming from the institute. Hopefully, you members will have an input in them. But the scenario was, or the intention was, to cover both human beings and legal persons, whether they are, in the form of a company or corporate persons or unincorporated persons, but that's a bunch, an association of people as a partnership or as a business name. Council Mujuda can add to what I've said.
All right, Council Mujuda.
Sorry, I had been logged out. But I think from what I picked from Councillor, I think she has ably covered the issue of, I believe we're discussing the issue of registration of firms. So I think what I get clear from the Act is that most likely with what the proposal that he has put, like the last one, to make sure that there's no firm that is formed by non-practitioners in the first place. So the firm will have practitioners. Secondly, if the institute takes the proposal that has been made by Councillor to ensure that only practitioners would become partners, and it is expected that those partners, again, you might decide to say, for one to be a partner, how many years of practice, or will it be a fellow? At what stage will they be allowed to form a firm? I think under the legal profession now, one should have practiced for about 5 years. It is assumed that by that time, somebody would have achieved the requisite qualification and to ensure that they adhere to the professional conduct. So again, these are some of the prescribed modes that the institute would have to, and the membership would have to come up. Thank you.
All right, thank you so much. Registrar, do we have provisions in the current, governance framework that could shed more light on this provision based on probably modalities in place for the registration of corporate members and the like? What have been the standards that we followed?
Thank you so much for that question. There's a slight departure now. Under the old regime, the prescription was around, when we said corporate membership, was around the number of practitioners that the employer has or had then and we are still in the same phase briefly in this transition. This one, the difference is as highlighted that, look, there are people who engage into the realm of HR as an establishment, not you being employed. So that's the different dimension that this one has taken. And let me take advantage to highlight the evils that we're trying to cure here, or which have been cured here. You will note, firstly, that the people who could not employ proper HR, and then they will run in the name of we have a consultant and do all sorts of wrong things. And those people will not be checked by labor, will not be checked by ourselves. They have just registered something, a makeshift briefcase company with PACRA, and then they think they are okay. All these ills that our people have suffered, most of them were emanating from that. Number two, you will note that there was no specialization. The institute will go into matters to look at the standing of those that are forming. What are you specialized in? You remember we talked about the competence framework. You want to open this. Your strength is in this. How are you able to do this? If we are asked them to show proof of who else will be in their team, that will be another issue, just to take comfort that in the field or space they want to practice HR, we are comfortable that they can do all those matters. We will also cure the issue of there are faithful members who have opened consultants firms. They've been following the standards, while the masqueraders, so to say, could go free and just do as they pleased. But at this point, there will be standardization of how things are done. The last one is the benefit to the public. You will note that in section 29, at 2, subsection 2, there will be a register of those qualifying things. And I've seen this practice with LAS, for instance, with the Institute of Engineering to be particular, that they will say, these are the firms that you can deal with this year, so that the public is not misinformed, is not misguided, is not conned by crooks out there. They will simply refer to the register at inspection at the institute, or if we publish it in the papers, they will be able to say, is this firm we want to engage so registered? Because that registration, as we've said, gives the public confidence, because the registration comes after the scrutiny of that firm or the partners to be. So those are some of the things that we're trying to cure here. Thank you so much. Yes.
Thank you, Registrar. You've actually gone to answer the question that was going to be the last question on the Act. Section 31 explains exactly what you've just talked about. The registrar shall, in the direction of council, cause copies of any of the registers, including alterations, additions to those registers, to be printed and published in a manner and form that council may direct. So that provision is adequately provided for at the moment, and obviously there's the aspect of whatever is being published to be prima facie evidence in legal proceedings when it comes to whether or not somebody had a right to be able to practice. Now, very quickly, and building on this, why is it important then that members can make sure that their details are captured on a member management platform? I know we have been campaigning that everyone must have their records properly captured on the member management system, which captures details for both firms as well as details for individual members. Could it be deduced from here that the database that you would have under the system would be deemed as a database that would then become the source for any publications going forward? What guidance would you have for the people attending this webinar today?
Thank you so much. Yes. We will emphasize, and we have seen this. I'll give an example of the just ended AGM, where we did publish the list of paid up members up to the point of the AGM in the booklet. There were cries, no, my name is misspelled, oh, my name is this, my name is missing. Now, this system that we are preaching about, it gives members real way to check whether their details are sitting correctly before we publish, whether whatever details they want, to some extent, apart from altering other very prominent issues, edit of a name, change of location on this, it is in your hands to manage. So we are simply asking members to self-manage, so that whatever detail you want to appear in the register. I'll give another example where someone said, I don't want this name to be here. Meanwhile, they had given it when they started. Along the way, whatever happened, they divorced, and they hate that man so much, and she was speaking with emotions. I don't want this name on my document. Look, we published, before publication, we invited members, check on the website, are your details correct? You would have altered this. So this is what we're trying to do. And now, coming into the implications of what would happen, before the legality part of it, you know that there are sensitive people who follow, because there is a legal implication if you employ someone who is not qualified, that you are liable also at law. So people now will be very sensitive to check the publication of the institute. Imagine your name omitted and the prospective employer checks through the list and they don't see you. You may miss an opportunity, employment opportunity. By the time you are coming to rectify with the institute as to whether that opportunity will be still standing, we don't know. So we give you a chance to monitor and make sure that your details are correctly captured so that you are never disadvantaged in any form. Thank you, CS.
All right, thank you so much. The last questions that we have here in the chat are speaking to, I think there's some themes. The first one speaks to whether or not there's a way for the institute to compel employers to, meet the budget for CPD related, programs, or even membership. And in addition to that, whether there is a way for the institute to regulate conditions of service for HR people, because new entrants into the profession might not be able to, bargain for themselves very well, because obviously their bargaining power might not be as good as those that may have been around longer. Is there any modalities in place there? And then is there a registrar planning to write to employers to encourage them to come up with internship programs and policies to help graduates gain some experience? I think this is now speaking to member programs. Are there any programs that we want to be able to put in place to support the growth of members, in addition to the things that have just been spoken about here? And obviously another question is speaking to whether or not we will just get people that have been affiliate members for 8 years straight to full member, for example, or to fellow because they've practiced for a long time. And so are we going to just jumpstart them to a place where they can, easily hold office as director or manager? And lastly, protection of whistleblowers. There seems to be a concern that we are not providing on how we're going to protect whistleblowers. How are we going to protect whistleblowers? And then the last question is, when is this law effective? When does this become law? Is it law right now? Is it going to be law in the future? When does it become effective? I think those are the questions. And so in the interest of time, I'll allow that you actually deal with these questions as part of your closing remarks. And so I'll ask that all the discussants can then just take a swipe at the questions, and then along with just give your closing remarks. I know Councillor Ulaya has always gone first, so maybe she goes last this time around. All right. Councillor Mjuda, would you want to go first? Maybe Registrar you could follow, and then Councillor Ulaya can give her remarks last.
Thank you. I think this has been an interesting webinar. And I'll just pick up on one question. Is this law? Yes, it is. From the day the president signed it, was it on 8th April? It became law. My closing remarks is suspension and cancellation of practicing certificate. They are bad, but I think you'd want to stay away from a cancellation, as it might be a career defining moment for you. So stay away from all the two of them, but you don't want to ever get closer to a situation whereby your practicing certificate is cancelled. And I hope looking forward to the next webinar. Thank you.
Thank you so much, Councillor. Registrar?
Thank you so much. Yes. Thank you, all those that gave in this time to tune into this very important webinar in the law that is defining how the profession will trade going forward. Let me pick on a few questions. I think there were so many. And I mentioned I was trying to jot, but midway, I lost my way. Okay. So ably put, the law is in effect, I think from the 8th of April, as stated. So it's law now. Of course, with those transitional issues, but that does not stop it from being law. In terms of protecting whistleblowers, I think I did mention earlier that when we are approached in a manner that should not be publicized, we have a mechanism where we will, through inspections, go into an institution, but knowing at the back of our mind that there's an issue here. So we will conduct an inspection, and an informed inspection is better. Believe you me, if people are coming to search your house and they have inside information that the bag is under the bed, they will come straight to there, and you'll be shocked. How did they reach my bed? So it will give us very good insight on where to look. So by that, we'll not be disclosing your identity, but we would have known which issues to attend to. So you are well protected, be assured. So just reach out to us, and then we will do that. The issue of protecting practitioners, I must say that we are in a better position now, in a stronger position to stand up for our members. To start with, when we say we are speaking also as a membership. You yourself, you are in a better position. What used to happen is that if you, a strong person, is bargaining for something reasonable, they will do away with you, hoping to get the next who is not that licensed or qualified. So that was a disadvantage. But now you will stand a better chance because there's no masquerade. You know, the cheaper side is this, which is saying just for anything because they know they're in the legal position. But you are in the stronger position. The voice is one and it must be united. When we say the institute, let's not look at the building. The institute is us. We must have a strong voice, and we must not apologize for choosing the profession that we are. But directly, as a motherboard now, the institute, you can approach us. We have the mechanism to intervene in certain matters. You will see that the interest of practitioners have been mentioned directly in the law. We will advance those. It is for you, it is for us. The issue of the other issue was just refreshing me, CS, on one of those that we haven't covered.
There was an issue on whether we could, set some kind of rates that the industry could follow as minimum rates for HR practitioners, and also whether or not we could, compel or find a way of compelling employers to support our members with payment for CPDs as well as attendance of, events like AGM, summits, and the like.
Thank you so much. The issue of the minimum wage, we're discussing something, but I wouldn't promise now. You will know that we're operating in the free economy, but that does not mean we can't prescribe the minimum, as you've seen with others, but that is still under discussion. We cannot preempt. But above that, what I'll say, in the strength of the profession now, you know what the minimum is? It's not something to write home about. It's just something below which the employer should not. But as to whether it will attend to the needs of the practitioners, it's doubtful. We had an issue where members are crying that we are being given 50 kwacha per day. But when you looked at the minimum, it was maybe at 25. So what you are being given already is better than the minimum. So your cry. So that's not necessarily the cry that we must have now. The strength to bargain is what we should be looking forward. But directly speaking, the issue of minimum, yes, below which the employer should not go, is under discussion. And we can only share that once concluded. Compelling to some extent. I will emphasize again that the conditions of service really sit in your hands as practitioners. Couch them in a good way to also protect your interests. You know that these matters also hinge on motivation. If your employer can take you here and do this, that's motivation. You come back, apart from the knowledge that you gain, you will come back a motivated one, knowing that the employer cares about your development. This is not peculiar to practitioner only. When you are drafting this, now we are focusing privately as practitioners. You preempt certain things. You're not the only profession in your organization. So if you can't plan for marketers, you can't plan for lawyers, you can't plan for accountants, then you want just to plan for yourself. That will be questioning. Plan for everyone. And which employer will refuse that, so that you have the benefit? All in all, the conditions of service sit in your hands. So draft good things that will benefit, including you, because you are part of the conditions of service. I want to thank you and ask that we be good citizens, doing the correct thing, doing the right thing, and be good professions. When we give you the mandate to practice as human resource, do the correct thing, unlike what we've seen with masqueraders out there who have misrepresented us. No, HR has run away with money for the company. No, the conditions is HR who is blocking. We don't want to hear that. We want a productive workforce, and that begins with HR and almost end with you, because there are other partners that must join us. Thank you so much.
All right, thank you, Registrar. Council Laya. Maybe Council Laya, you could also, in answering the question around whether there can be any regulation of conditions of service, maybe you could, in a way, touch section 59, subsection, section 59, subsection 2H, which talks to the fees payable for professional services and any other fees that are required to be prescribed, and whether or not this would in any way provide the hope that members have towards getting some of these things regulated. Thank you.
Thank you, CS. Where we've come from in Geneva, I would have said I would like to align myself with the statement that has been given by the esteemed representative of the Zambia Institute of Human Resource Management, Honorable Shilala. So anyway, I think that the speakers before me have ably summarized what we intended to convey in this webinar today. And you preempted what my comment was going to be around the issue of minimum wages. Coming from the Ministry of Labor, I would say that the issue of minimum wages is a very, very thorny issue. And it would be very difficult to convince the tripartite partners that HR professionals are a vulnerable group that needs to be protected. Because the moment we begin to accept that fact, then what are we saying about the people that are under our charge? Because conditions of service are under our purview. We as HR practitioners are the ones that guide. Having all of these parameters that had spoken about the law, public policy, when you've understood the essence of compensation and benefits, your target is towards having a workforce that is sufficiently remunerated, so that they are sufficiently motivated, so that there is productivity in the workplace. So if you the person that we expect should be in the forefront of leading out in these discussions on conditions of service is running to the minister for protection so that you have a minimum wage. It sends a very wrong signal. It sends a very wrong message. I doubt it very highly that this is one of those issues that would be considered from a public policy point of view. But all is not lost, because Section 59 G that CS mentioned there is one area that I think can be looked at quite seriously, so that you come up with a statutory instrument that specifies charge out rates. All right. You don't need to reinvent the wheel. Lawyers do it. So if you're at a certain level, say 4 years and below, for doing conditions of service per hour, you can charge so much. If you are at 5 years to 9 years, this is the rate that, and it keeps increasing as your years of experience go. In that way, when there are charge out rates, it is hoped that you can use that as a bargaining tool. And if you have an employer who really will not give it a shot, you will then have an option, all right? If you're going to have rules that say if you have 5 years of practice and more, you can go and set out a firm. And you have that requisite qualification. If your employer is not giving you that amount of money that you think you are worth, and you know, with the experience that you would have garnered at that particular stage, you would be able to set up your own firm. Why not just go and set up your own firm and get that money? You can even set up an HR consulting firm. And if this person doesn't get HR practitioners in-house to give those peanuts to, then they'll be forced to come to your firm and hire you at a consultancy rate. So this is what we are hoping, that by coming up with these SIs specifying minimum charge out rates, there can be a domino effect or a ripple effect that will see changes, you know, upwardly for the better in conditions of service for HR practitioners. I have seen this worry about whistleblowers. That's why in the first webinar, I had talked very strongly about the sort of trauma that I have seen exhibited by HR practitioners. And this worry here is a holdover, you know, from the previous regime of or order of things, where we were really, really traumatized as HR practitioners. And so if you still feel, I'm not so sure the law will protect me, and you want to whistleblow, I just wanted to say, hey, be in good books with your neighbor or a very good cousin who will not spill the beans on you. Ask them to send that email. I'm sure you can even drop an anonymous letter. That is done at the Ministry of Labor many times. And in your workplaces as HR practitioners, you get very shocked how, when we come, as a registrar had said in his example, we come straight to your bedroom, under the bed, and we find the hidden stash of money, and you start wondering, how did they know? So Ministry of Labor is grossly understaffed. And so we are very, very targeted in the way that we do our inspections. And the vast majority of them are on account of the whistleblower messages or tips that we get. So use whatever avenues, be ingenious in the way that you send out these messages out. You can actually even specify, I want to remain anonymous. We respect that particular provision, and I've worked with people in the Secretariat. They are quite professional. I don't think that they would want to jeopardize any of your standing or, you know, your positions at work by revealing who the tip had come from. I wanted to end with the issue of registers. The law, you know, for those that were registered already, has recognized that prior registration as still being valid. And I would just urge the practitioners to take an active interest, check online. If you're in Lusaka, even just pass through Secretariat, just see how the institution is, where it's situated, and check for your details. The law says the particulars that are on the register are prima facie evidence of whatever is contained there. That is a good thing. That means that what is on the register is taken as the truth for so long as there isn't any contrary or opposing, or further evidence that is brought. So if you have a name there that you want to change, you can still go and change. If it's not there, it's not the end of it. You will not say, now I'm done, I'm doomed, I will not practice for the rest of the year. If you had paid money, take the evidence that you had paid, and then the Secretariat would put your name on that register. So I would just want to urge everyone to take advantage of this very new and progressive law that is there, to make sure that you are aligned and begin to assert yourself. Like I had said previously, enough of being scared. You have a very strong law. I don't know how I can overemphasize this point. You have a very strong law. It's still early days. I would not fault you in being this scared, but if there's any assurance, just know that there is enough protection to allow you to work and to thrive in your particular endeavors. So my ending words for today would be familiarize yourself with these provisions. What we dealt with today is the heart of the law. The next webinar, I believe, will be talking about another correspondingly important part of this law, which is disciplinary matters. And for that one, I am hoping we will not get a lot of cases around that particular issue, but just know that in case you decide you want to be cantankerous, there are disciplinary committees set there with a lot of powers to take away your livelihood. So with that fear, with that whip ready to put you in line, I wish you all the very best. I know you are all very professional people. Let's get out there and change the face of the labor market for the better. Thank you.
All right, thank you so much. I've seen this request from Julius that we've not adequately answered the question on CPDs and whether the institute can compel employers to support members during AGMs, conventions, CPDs, including probably membership. I know that you've touched it, Registrar, but maybe in less than a minute, could you just try and re-echo what the response is there in very simple terms, without taking a lot of time. Thank you.
Thank you, CS. To compare, no. We will compare the practitioner, but to compare the organization to pay is a different matter. We can engage, but not to compare. Thank you.
All right, thank you so much for that response. And ladies and gentlemen, you have it. Thank you so much for making a date today. It's been an exciting 2 hours. I just realized that it's been more than 2 hours actually, but it's been interesting. Thank you so much for staying glued. We have the next session in exactly 2 weeks. So that is a week after next week. And we are going to be looking at part number 4 and 5, I believe. We'll be looking at matters that pertain to disciplinary as well as the inspectorate. You want to come and learn how these 2 areas are going to be operationalized. But very importantly, and allow me to emphasize again, like the discussants have been mentioning, we're at a stage where we need to shape how these things are going to be done. Most of the things require a lot of thought. Most of things require a lot of discussion and your participation. For example, there's a whole constitution to be drawn. There's a whole competence framework to be drawn. There is a whole code of ethics to be drawn. And these things will define how things are going to be done. At this stage, you are all encouraged and urged to ensure that you've participated, that you have, provided your input, that you have followed all the deliberations and the discussions very, very keenly to ensure that, we do not leave out those brilliant ideas that you may have around some of these issues. And so I'm not sure the president made it to this discussion. He was held up somewhere. And so I'm still not able to see him. I think on behalf of the Institute and the Council, allow me to just say thank you so much. And we look forward to hosting you again in 2 weeks. Thank you so much.
Thank you, CS, and everyone. Have a great weekend, and we'll see you in 2 weeks. Bye-bye.
Thank you.
Thank you. Bye. Thank you.